Acton versus Vernonia. Before this case fully set into motion, the school district and the school of Vernonia were very concerned with players of their teams using drugs and other substances, as that is a risk for injury. The Vernonia School District later adopted a drug testing program that would allow them to test any and all student athletes for drug use. The case was really set into motion when James Acton, a student athlete on the football team, was asked to take the drug test, but later refused and was then kicked off the football team. The Actons later came back and said that this was a violation of James's Fourth Amendment right, and they said that random drug testing was against the Fourth Amendment regarding search and seizure. Their case was later taken to the Supreme Court, where it was first argued on March 28, 1995. In a 6-3 decision, they ruled that it was constitutional because it was in the government's interests to stop kids from using drugs. They also said that because these students were using drugs, they were putting themselves and others at harm. And while at school, students are under the jurisdiction of all the teachers, and the teachers must keep them safe. The only real implications of this case would be that other schools would adopt this same drug testing policy.
Board of Ed versus Earls. Citing a nationwide drug epidemic and a school survey saying that more than half of the previous graduating class had used illegal drugs before finishing high school, Tecumseh High School and Middle School in Oklahoma mandated drug testing for all students participating in any extracurricular activity, not just athletics. The urinalysis test must be taken at the beginning of any season or activity and can be re-given by the school at any time. 2 students, led by Lindsay Earls and her family, felt that this testing violated the students' Fourth Amendment rights to privacy against unwarranted searches and seizures. On June 27, 2002, the Supreme Court ruled in a 5-4 decision that random and mandatory drug testing in high schools did not violate students' Fourth Amendment rights. They cited how the Vernonia v. Acton case was consistent with the Fourth Amendment and that the way the school was collecting the urine samples was minimally intrusive upon the students. The only possible implication of this court case is that more high schools decide to mandate drug testing for any or all of their extracurricular activities.